Thank you.
Colleagues, good afternoon. It's February the 25th. It's 1 p.m. and it's now time to have our House Economic Matters hearings. We have several bills today and a lot of witnesses on some. So please be concise with your statements. And if you can say me too, that is always much obliged. Please, if you're listening or participating, understand that the chat is for members only. So please do not enter in, and also as well keep yourself muted unless you're asked to be unmuted or it's your time to speak. We will start with our very first bill, which Delegate Chi, House 866.
Thank you, Chair Wilson and members of the Economic Matters Committee. I am Delegate Lily Chi here to present HB 866. HB 866 is a consumer protection bill that protects the consumer's privacy and rights when it comes to their genetic data in the context of genetic testing. As I'm sure you're well aware, direct-to-consumer genetic testing companies such as 23andMe and Ancestry have become increasingly popular as more Americans want to know about themselves and their family heritage. As such testing becomes more prevalent, it is imperative that we step up our consumer protection laws as it relates to such matters to keep up with the changing marketplace. So HB 866 provides more privacy protection to ensure that consumers are in control of their genetic data at all times. It will allow Maryland to join states like California, Arizona, and Utah in having the strongest genetic data privacy protections in the country, and fill an important void in our state's current consumer protection laws as they relate to such matters. Specifically, this piece of legislation puts forth 3 requirements for direct consumer genetic testing companies. First is disclosure. The bill requires companies to provide consumers with clear information about their policies and procedures on the collection, usage, and disclosure of individuals' genetic data. This information must be publicly available and easily accessible. 2 is express consent. Companies must obtain clear consent from consumers before collecting, using, or disclosing any of their genetic data. At each of these steps, companies must obtain the consumer's express and separate consent. 3 is protection. Companies must develop and implement policies and procedures to ensure the protection of consumers' genetic data, including how such data can be shared with law enforcement and other government agencies. Such policies should also allow the consumers to easily access their own genetic data, delete their account and the genetic data, and request the destruction of their biological sample, for example. Currently, members of the Coalition for Genetic Privacy already comply with the privacy and disclosure standards written within this legislation, but this bill would ensure that all direct consumer genetic testing services comply as well and establish a clear industry standard. It is important to note that this bill does not apply to protected health information that is collected in accordance with the federal regulations or to higher education institutions. And I'm aware of the Office of Attorney General's proposed amendments, including exemptions and applications of this legislation, which I'm happy to work out with OAG. So with that, thank you very much, Mr. Chair.
Thank you. Call for first witness, Caitlin McDonough. We'll call after this bill.
Thank you, Delegate Wilson and members of the committee, or excuse me, Chairman Wilson and members of the committee. Caitlin McDonough here on behalf of the Coalition for Genetic Data Privacy, here in support of Senate Bill 866. And thank you to Delegate Chi for working with us on this issue. I'm not going to recap Delegate Chi's testimony. I think she's already kind of gone over much of what the bill does. And again, we just, as our members are already complying with much of this, what this legislation would require, we think it's important that these robust consumer privacy protections be put in place to ensure consistency across the industry and make sure consumers are aware of their rights and protections under the law. Essentially, the bill before you is almost identical to what's already passed in California, Arizona, and Utah, as the delegate mentioned. And I'll just note that in going through those processes in other states, we worked out a lot of the issues and we believe the bill before you has the exemptions that are needed to protect HIPAA institutions, to protect higher education institutions, and allow for research similar to what's done for pharmaceutical companies now. We're happy to work with the Attorney General's office on some of the amendments they have before us, and I know Ancestry behind me is going to address some of those specifically. But the only other thing I'll note for this committee, because I know there was a lot of other privacy and consumer protection legislation pending before it. This legislation.
Ooh.
I'm sorry.
Well, I'm sorry. Thank you.
Okay. It works with the privacy legislation that's before you. It's designed to be interoperable. So, if there's any concerns about that, we're happy to address them. So thank you, Mr. Chair, and I'm happy to answer any questions. Thanks.
Seeing no questions, move on to Richie Englehart.
Good afternoon, Mr. Chairman and members. I'm Richie Englehart, Head of Government Affairs at Ancestry. Along with our coalition partners, including 23andMe, we support HB 866, a bill that will ensure that consumers have control over their data, are presented with easy to understand privacy policies, are empowered to make decisions on how that data should be used, including a requirement they provide express consent anytime their data is shared with a third party, and can end their relationship with us at any time and delete their data. We've supported similar bills in Arizona, California, and Utah, where the measures passed with bipartisan support and broad stakeholder consensus. I do want to address the concern raised by the Attorney General's office regarding de-identified data in their written testimony. The exemption for de-identified data in this bill tracks to both HIPAA and the Common Rule, the federal laws that govern privacy in the healthcare and research settings, respectively. Additionally, the bill before you would provide stronger protections for genetic data than either HIPAA or the Common Rule. And these strong protections have been a part of our terms of service since 2018 and are already in statute in other states. In fact, the very California law that the AG's office asked to align this bill's genetic data definition also includes an exemption for de-identified data, as do the General Consumer Privacy Acts that have passed in California, Colorado, and Virginia. This bill only allows an exemption for data that we have committed to use in de-identified form, take measures to prevent the data from being associated with a particular customer, and contractually forbid anyone we share de-identified data with from even attempting to re-identify it. This is the standard for de-identification in HIPAA, the Common Rule, other state privacy laws, the Federal Trade Commission, and the National Institutes of Health. There is no rationale for Maryland alone to impose further restrictions on the use of de-identified data as defined, and doing so could have a chilling effect on research in the state. We urge the committee to favorably report HB 866 without the suggested amendment on de-identified data. Thank you, and I welcome any questions the committee may have.
Delegate Pippy.
Thank you, Mr. Chair. Is there anyone else going to testify, or should I wait to the end to see if the answer, or just go?
We have several other people willing to testify if you'd like to wait for a moment.
I'll wait. Yep.
Okay, we have Steve Sakamoto-Wengo.
Thank you, Mr. Chairman, members of the committee. Steve Sakamoto-Wengo from the Consumer Protection Division of the Attorney General's Office. Actually here in case there are questions, but I'd like to defer to my colleague, Hannah Abrams, who's here to testify.
All right, we can call on Hannah Abrams then.
Good afternoon, committee members, chair. My name is Hannah Abrams. I'm an Assistant Attorney General in the Consumer Protection Division of the Attorney General's Office. Thank you for letting me speak today. As you know, genetic information constitutes the most sensitive and personal of information. It uniquely identifies an individual, reveals their propensity to develop certain diseases, and exposes genetically related family members. We commend this committee for considering this bill, but we offer some amendments to ensure that it accomplishes what it sets out to do. The Consumer Protection Division strongly supports providing consumers with rights and protections in connection with their genetic data. However, the bill as drafted raises some concerns, and we've offered some amendments. First, the carve out for all educational institutions, whether it exists, and it carves out entities that are public, private, nonprofit, or for-profit, as well as any entity owned or operated by these institutions. This is extremely overbroad. First, one of the hallmarks of a for-profit educational institution is the lack of academic research. There's no reason to exempt for-profits. And second, most of the health-related research conducted by academic institutions is conducted by entities already covered by the HIPAA exemption and their business associates, and they're already exempted from this law. The division recommends eliminating the carve-out for educational institutions. Second, we've offered some amendments to the definition of genetic data, that it should include information that's extrapolated, derived, or inferred from a genetic analysis, because, and this conforms with language that that has been offered in connection with the Maryland Personal Information Protection Act that's also being heard by this committee today. You've heard the issue of de-identified data being raised. It's entirely carved out from this bill. That means that the minute it's de-identified, there is no protection whatsoever.
I need you to wrap it up. Given 2 minutes, I kind of need you to wrap your testimony up. There will be questions, I'm sure.
Sure. It should be clear that the de-identified data can be re-identified. So to the extent that the committee chooses to permit this exemption, they should understand that it is not anonymous. We urge a favorable report with these amendments. Thank you very much.
Okay, we have one more favorable, Isidore Stern.
Mr. Chair, I believe she's written.
Oh, apologize, good looking out. Okay, so before we begin, Steve, I have a question. So how do you feel that the Attorney General's office is going to assist in the enforcement of this bill?
Well, as we do with other cases, if we get notified or we get a complaint showing that there might be a violation, then we would, investigate, and, if we can resolve it voluntarily, resolve it voluntarily. If not, we would, bring an enforcement action.
I'm so glad to hear that you guys have the ability and the people to enforce these kind of bills, because I will be coming to you later for other bills that in times past you said no. And it's very good to hear that you're going to be, you're willing to enforce these kind of bills. Jesse Pippy, Delegate Pippy, apology.
You're right in both responses. So I saw a similar bill when I was on the Judiciary Committee, and it obviously pertained mostly to law enforcement, because just for some background, law enforcement uses DNA. Let's say they may pop off a soda can from a relative to solve crimes, particularly old crimes or indirect, because people share common DNA strands and whatnot. So my question is, and I know it was alluded to earlier, so you sign up for 3andMe, or 23andMe, whatever the name of the third party is, and how does the law enforcement come into play here? I know there's an exemption here for educational purposes. I'm not seeing an exemption for law enforcement. So I'm assuming if you don't either opt in or opt out or give them express permission to use your DNA for any other purpose other than educational, does that mean that law enforcement could not, under any circumstances, and I guess I'm saying it for state because I see there's a federal exemption in there somewhere, but if somebody could just help me out with the law enforcement component. And then the second part of the question is this going to be an opt-out? Like, so if I log on to this site, sign up for it to see what my background is, do I have to opt in to say you can use it, or do I have to opt out? If someone could answer that.
I'm happy to take the question. So the bill requires a valid legal process before any data can be shared with law enforcement from a direct-to-consumer genetic testing service. The websites that law enforcement typically uses to conduct forensic genealogy searches are not websites like Ancestry and 23andMe. There's a third-party site called GEDmatch, which is an open-source DNA database. And basically, GEDmatch was started by genealogy hobbyists, so that if I did Ancestry and Caitlin did 23andMe and you did MyHeritage, we could download our information from those services and then upload it to GEDmatch and see our matches across platform. That's the service that law enforcement used, and it's in the terms of service for GEDmatch when they caught the Golden State Killer. Now it's an opt-in. At the time it was opt-out. But neither 23andMe nor Ancestry allow law enforcement to go into our databases. And I want to make very clear that that's in this bill, that we can't share data with law enforcement without a valid legal process. And to the question on whether it's opt-in or opt-out, all of the express consents in this bill are opt-in. So you have to answer separate questions. Can we analyze your biological sample? Do you want to see genetic relatives? Do you want to participate in IRB-approved research processes? Do you want your sample stored? And those are all separate questions in the sign-up flow. Nothing's buried in the terms of service, and this bill doesn't allow us to bury it in the terms of service.
So it's a more explicit disclosure, and the assumption of this bill is that they cannot share any of it just by signing up anymore. You'd actually have to sign up and then give them express permission within the site up front before they could then use your DNA to participate in other things other than education.
Correct. And even for educational research or IRB approved research projects, the consumer has to provide informed consent for that, like you would for any clinical trial or human subject research. All of that's governed by the common law.
Okay, thank you.
Delegate Howard.
Thank you, Mr. Chair. So the testing is not contingent upon the waiver. So in other words, if a person opts in or out of different selections of the testing and for test results, they can still get the test.
But by and large, that's correct. If you don't provide consent for us to analyze your sample, obviously we can't run the test.
Certainly.
So
certainly.
like that's a pass-fail question. But if you don't want to see genetic relatives, you can still get your test results. If you don't want to participate in research, you can still use the service, see how much DNA you have from Britain or Germany or what have you. All of those are separate, and none of them are contingent on your use of the service isn't contingent on those separate questions.
What about the use of the service contingent upon privacy and data transmission to a third party or another company if I opt out of that?
No, this bill requires that we get separate express consent before sharing that data with any third party. The only exception would be for vendors or contractors. So obviously we don't get a separate consent to send your sample to the lab, which actually does the analysis. But those are only the third parties that are service providers that help us deliver the service.
Okay, so you wouldn't be stopping someone from getting this type of testing if they said, no, I don't want you to share any of my data at any time.
Absolutely not. In fact, if you wanted to get the test done and just find out what your genetic information says about your genealogy or your health risks, and then close your account and delete all your data the next day, we allow for that.
Okay, fantastic. What about data before this bill? I did 23andMe years ago. What about the data before this bill?
Well, I'd have to know when exactly, right? Because we've been bound to these terms of service since 2018. So if you did it years ago, meaning 2019, 2020, these same rules would have been in place at that time. Mm-hmm. Before then, we had different protocols in place, but they were still very privacy protective. I can get more information on kind of the historical use of data, but everything is now governed by these terms of service, which have been in place since 2018.
Fantastic. And just a quick follow-up, Mr. Sakamoto Wingo, how do you rectify data that's been sold or transmitted? I mean, that's sort of the once the toothpaste is out of the tube argument to me.
Yeah, I guess the idea is to hope that the penalties that you would have for violating the law would be a deterrent.
Well, how do you make the person whose data has been sold whole?
You have to get them your restitution based on the violation. So, I mean, you can't, like I said, you can't recapture it, but you can, try to get restitution to try to deal with that.
Okay, and very quickly, in just 10 seconds, walk me through the restitution. What is that? What does that mean?
Restitution would be if the person can show that they were damaged as a result, any money that was wrongfully taken from them in connection with the violation could be ordered to be returned to them.
Yeah, but this is about their privacy.
Right, this is about privacy.
Right.
So.
Okay. So, I think I got my answer.
Thank you. Seeing no other questions, we'll move on. We're going to skip out of order right quick. Delegate Forbes, are you still on?
I am, Chair Wilson, but I'm in a voting session and appropriations. If you could move me later I would really appreciate it.
Okay, we can try. Delegate Carey, 962.
Thank you, Mr. Chairman. Good afternoon. Good afternoon, Vice Chair Crosby, members of the committee. For the record, I'm Ned Carey, here to present House Bill 962. House Bill 962 is a bill that strengthens the Maryland Personal Information and Protection Act, better known as AMPIPA, in response to changes in the type of data being collected about consumers. An important note to this bill is that House Bill 962 addresses responses to data breaches, not to be confused with data privacy bills. This bill does not address the type of data companies can or cannot maintain. It simply seeks to ensure that whatever data they have is protected and that you are notified in a reasonable time frame if their system is breached and your data falls into the wrong hands. The data collection landscape, as we all know, has changed dramatically since the last update of AMPIPA, which was in 2017, and continues to evolve. Consumers are giving even more personal information in order to take advantage of new technology of apps and services that can enhance their lives. So this bill accordingly, number one, expands the definition of personal information in the statute to include genetic information that we've been talking about. Genetic testing services offer the benefit of connecting you with relatives and helping you discover your lineage. They can help you with health plans, provide numerous other services. At the same time, your DNA is among the most personal and sensitive pieces of information that companies collect about you and should clearly be included under the definition of personal information. Number two, House Bill 962 also streamlines the industry's response to data breaches by expediting the notification process, giving consumers the power to make changes before they experience a problem as a result of a breach. Many businesses store and protect their data through third-party maintainers of data. This bill changes the time frame for a maintainer to notify the business owner or licensee from 45 days to a maximum of 10 days. This requires the maintainer of the data and the owner of the data to start the dialogue early and remain in contact throughout the investigation. Also, consumer notifications and trigger. Under the current law, once the data owner or licensee discovers or receives notice that there has been a data breach, they have 45 days to notify the consumers after they've concluded their investigation. Because of this, companies can extend their investigation over months and even years in some cases, such as Google, who notified consumers 3 years after their breach. This bill requires them to give notice no more than 45 days from the time they are made aware of the breach. This is a necessary change because under current practice, by the time the consumer is notified, it's become moot. There are provisions in the bill that would allow for a pause if the notification would impede a criminal investigation or undermine national security. The bill also strives to ensure that consumers actually receive notification by no longer allowing the substitute notice to be the primary means of notification, such as setting up a web page for consumers to check if their information was compromised. Data owners and licensees are required to notify customers directly by written notice, electronic mail, or hard mail. The only exception is if the company has neither the mail or the addresses or any other means of notifying consumers. This bill, House Bill 962, is basically the same bill that I presented to this committee last year, House Bill 148, that was actually passed out of committee and passed out of the House. 2021's HB 148 was the result of 2 years of collaboration to a good end. The protections and notification provisions of the bill were agreed upon. And this year for House Bill 962, we continued with that spirit of collaboration to make minor changes that actually help clarify intent and definitions. We've had discussions with each of the organizations that's uploaded favorable with amendments and unfavorable written testimony, and they have been satisfied with where we've landed. Notably, we've been working with the likes of Mr. Andy Klingman of the State Privacy and Security Coalition that represents numerous companies and industries and have reached agreement on requests in his testimony, several of which have resulted in the amendments in your packet today. He's satisfied with where we have landed. We echo his sentiments that it has been a good working relationship, and we appreciate his accessibility and flexibility. And I would also like to say the same about Ms. Caitlin McDonough, who we've worked extensively with on the genetic information part of this bill. The two main concerns that were addressed by the amendments in the packet were the definition of genetic information. As I said, we've worked with the Coalition for Genetic Data Protection and agreed to amend the definition, which is identical as it is in the California law, as she said in the other bill. The lack of clarity regarding how much time a company has to make notification. If the law enforcement investigation concludes early, businesses still have 45 days from the date of awareness of the breach, even if the investigation closes early. Lastly, the timeframes for notification have been negotiated over a period of 3 years. And while any business would always like to have as much time as possible, the request for more time arises from a desire rather than a need. Today's technology allows for quicker responses. And as I've mentioned, we haven't updated these significant elements in AMPIPA since 2017. 5 years is a long time in the cyber world, as we've all seen. These updates are necessary to protect Maryland consumers in this rapidly changing cyber environment. And it's for these reasons I urge a favorable report on 962 as amendment. And Mr. Chair, I have my panel members, Mr. Steve.
I've got him, buddy.
All right, to help speak to any details or assist me with answering any questions.
And colleagues, I would again remind you to please be brief in your recitation and your questions. We have a multitude of hearings today, plenty of witnesses, so please paraphrase when you can. And me too.
That wasn't brief, Mr. Chair?
I'm sorry?
I'm sorry, I thought that was brief.
Ow, that was emotional, brother, but that's fine. Okay, we'll go to our first witness on your Steve Sakamoto Wengo.
Okay, thank you, Mr. Chairman, members of the committee. Steve Sakamoto Wengel on behalf of the Consumer Protection Division of the Attorney General's Office. I'd really like to thank Delegate Carey and his Chief of Staff, Patrice, for their hard work in bringing all the stakeholders together to try to work out the compromises necessary to bring the Maryland Personal Information Protection Act into the 21st century. Once again, I'd like to defer to my colleague, Hannah Abrams, to go into the details of what this bill accomplishes. Thank you.
Thank you very much, Steve. Go to Ms. Hannah Abrams next.
Mr. Chairman, committee members, my name is Hannah Abrams. I'm an Assistant Attorney General in the Consumer Protection Division of the AG's office. Thank you for letting me speak today. As Delegate Carey explained, the Maryland Personal Information Protection Act, or MPIPA, is a data security statute. All it requires is that businesses that collect consumer data maintain it securely and notify consumers in the AG's office if there is a breach. The amendments here are the result of extensive negotiations. And again, I commend Delegate Carey's office for those. They've really tried to listen to every one of the stakeholders. It adds genetic information to the list of personal information that businesses are obligated to maintain securely. And adding genetic information to MPIPA simply means that if a company collects it, they must take reasonable steps to protect it and keep it secure. It does not impact how companies use this information. HB 962 also updates the notification timelines and requirements. My office's experience with the current notification timeframes is that businesses are able to use it to drag out and delay notification. HB 962 remedies this by shifting the trigger for the notification clock to the discovery of the breach rather than the conclusion of the investigation. Businesses are still allowed to investigate, but the investigation serves to toll the clock rather than delay it entirely. Many states use discovery of the breach as the trigger, including Colorado, Florida, New Mexico, Ohio, Tennessee, Vermont, Washington, and Wisconsin. People deserve to know about a breach as quickly as possible. The bill also asks companies to notify consumers directly where possible. And finally, the bill gives companies clarity on what to include in the breach notice to our office. That will get us the information that we need to help consumers as quickly as possible and to evaluate the breach itself. Thank you. And I'm happy to answer any questions.
Thank you. I just have a brief question for Steve. Sakamoto Wengo, do you feel that you, as the part of the Attorney General's office, will have the manpower to enforce this bill?
Well, once again, we currently are enforcing, breach violations where companies aren't protecting the data. We always have to balance, which cases we're going to bring based on available resources, but being able to have the tools that we need to be able to protect Maryland consumers, is important and gives us that ability to, bring an action where necessary.
Was that a yes or a no?
That was a yes, but we can't bring every single case.
No, I
You
totally
have to
understand.
bring enough. Yeah, but yes, this is a statute we're currently enforcing, and the amendments to that statute will make it easier for us to enforce that.
Thank you
law.
very much. Seeing no further questions, we'll move on to the very next bill, which is Delegate Abrams. House Bill 1135.
Thank you, Mr. Chairman, and happy to be here today to present House Bill 1135 for business regulation related to consumer deposits. The committee knows we've had similar versions of this bill in years past, including one brought by our prior chairman. These bills have
We should not mention his name again on this committee.
Okay,
No.
that's right.
I'm
I'm still a fan of Derek Davis's. I'm sorry.
Just playing. Go ahead.
So the bill has failed in the past for some fundamental reasons, but at the end of the day, I revisited the issue and I wanted to share with the committee the rationale for the bill and why I think it's important to pass. There are consumer financing products in the marketplace. Consumers use this, for example, for unexpected car repairs, say tire replacement, furniture purchases, appliances, HVAC, and lawn and garden purchases. And you'll know these programs because they offer consumers extended financing terms, sometimes with 0 or low percent interest rates. They defer interest. They can create equal pay and no payment of interest during the term. And so the reason why it's important to share with the committee that these consumer financing products exist is because in some cases, home improvement projects are expensive, but they're also in some cases desperately necessary. So for example, a roofing replacement. And when consumers don't have the money for these types of purchases, they do turn to financial institutions to complete the transaction. So let's take, for an example, a $20,000 roofing and siding project. I'm just using this by way of an example. Some of these consumer financing products would allow for 60 months of no interest but equal payments, which would be about $330 a month. There are different products of the same variety that would have no payments and no interest for 18 months. So they'd pay that $20,000 within the 18-month period and have no interest paid. And then sometimes there are low interest fixed monthly payments. So an example like that might be 1.9% financing, like you buy a car, for example, over 60 months, and that might be $425 per month. So you get the gist of this. The idea is to give consumers the ability to pay for expensive home improvement purchases in a way that meets their budget. The rub ultimately is that Maryland has, and we're one of the relatively few number of states that have regulations on home improvement contracts and deposits that are paid. So in that roofing project, the law, Maryland's law, only allows for $6,600 of that $20,000 project to be paid up front in the form of a deposit. Many of these, in fact, almost all of these consumer financing products are available through the retail chains that consumers would go to buy that roofing project. In some cases, the contractors are also able to give consumers access to those consumer financing companies. The problem is they can't finance the full $20,000 because of Maryland's law. They can only finance a portion of that, leaving the contractor and the consumer stuck in a difficult position for which this bill attempts to resolve it. So in this scenario, I believe that we're trying to respond to a general issue in the marketplace, which is that consumers may very well demand and want these products, and the Maryland law does not allow for that. Keep in mind that the financial institutions article includes regulated banks that do protect consumers' interests when payments are made. These are similar to credit cards in their terms and conditions. So there are clawback provisions if work is not completed correctly and consumer complaint happens. And to be blunt, Maryland does have the Maryland Home Improvement Commission that will stand in line and support the consumer if there is a problem. The last comment I'll make to you is that many of these consumer products require reputable contractors to become part of their partner agreement, submitting tax ID information as well as insurance information. So these are reputable companies. Failures, I would suspect, as with any bank, would result in perhaps the products being removed from the contractor's ability to use those. So the long story short is that this bill matters, certainly to contractors and cash flow, but we really thought of this through a new lens without rehashing past legislation, and that is to think of it through the consumer's eyes and attempt as best we can to give them the tools they need to afford what can be very expensive home improvement projects, sometimes necessary projects that they might not be able to afford, and do it in a way that meshes with Maryland law with this law change. So, Mr. Chairman, thank you for the opportunity to bring the bill and would ask the committee's favorable report. Thank you.
Thank you, witness Brian Gambarini.
Thank you, Mr. Chair. Good afternoon, Chairman, Vice President Crosby, and members of the committee. My name is Brian Gambarini. I'm the Senior Manager of State and Local GR. Excuse me, I said Vice President. Sorry, Chairman. I like Chairman Crosby. I'm sorry about that, sir. I'm here today to voice support for HB 1135, as Delegate Adams has said. As Delegate Adams brought up, several members of this committee heard a bill like this in the past around the partial pay statute. But after getting feedback from you all, the Attorney's General staff and other stakeholders, 1135 is a new approach that keeps the current protections in place. HB 1135 addresses the financing of these projects and will increase access to credit when planning critical projects at their residents' homes. I would like to reiterate that this bill keeps the current partial pay regulations for customers and contractors in place, and instead targets improving access to financing options for their customers. Improving access to credit will help the Maryland consumer. According to the Consumer Protection Financial Bureau, good credit means access to better financial products, and 1 out of every 6 adults are credit constrained here in Maryland. This bill opens opportunities for Marylanders that take advantage of the various financial products Home Depot, like retailers, offer through our reputable and regulated financial institutions. Under the current law, only a third of the cost can be financed at signing, and sometimes financed at a later date, which can be difficult. Between those times, a customer's financial situation can and does change. Circumstances like an unforeseen emergency, car trouble, childcare expense can impact the customer's ability to receive the same financing options for the remainder of the cost of the project. That's why we're supporting this provision today. Partial pay statute has created a patchwork of regulations around this area. And while we understand that there's not a desire to completely undo those, we're trying to look at ways to loosen this regulation in respect to financing. Thank you for your feedback and for considering a favorable report on 1135.
Thank you. Paul Giannetti.
Chairman Wilson, Vice Chairman Crosby, and honorable members of the committee. My name is Paul Giannetti, and I'm the Mid-Atlantic General Manager for Home Depot Installation Services. I've been with Home Depot for 28 years and oversee 92 Home Depot stores and thousands of installations across the Mid-Atlantic region. On behalf of the Home Depot and our 8,000 plus associates across the state of Maryland, I'm here to testify in support of House Bill 1135, Business Regulations, Home Improvement Contracts, Deposits by Financial Institutions, introduced by Delegate Adams. The Home Depot is proud to serve residents across Maryland as part of the support providing installation services that are conducted by licensed, insured, and dependable contractors. We offer a wide range of installation services from carpeting to windows, and at times these projects are critical upgrades for homes needed to maintain the comfort and safety, particularly at a time when people are spending more money and more time at home. Without a wide range of financing options, Most customers that contract with the Home Depot for installations would have great difficulty in affording these services. To service our customer better, Home Depot offers two options for financing. Under the current partial pay regulations, our credit offerings can expire, leaving the customer with having to find alternate financing, or the credit offering could be impacted by the installation schedule at a time when they're focused on the needs of their homes. That's why we believe addressing the financing portion of House Bill 1135 will benefit our customers and keep our current consumer protections in place. Maryland consumers deserve the same benefits of financing as the customers in the surrounding states, and this bill would help ensure that they are able to receive these when contracting with the Home Depot for installation services. I would like to thank the committee for considering this bill and ask for a favorable report on House Bill 1135. I'd be happy to answer any questions.
Seeing no questions, we will now move on to the next bill, which is Delegate Forbes, House Bill 917.
Thank you, Chair Wilson, Vice Chair Crosby, members of the Economic Matters Committee. I really appreciate your indulgence when I had to be in an appropriations voting schedule that the time shifted. For the record, I'm Delegate Kathy Forbes, and I'm here today for testimony in support of HB 917. This bill would increase the amount a homeowner can recover from the Maryland Home Improvement Commission Guarantee Fund from $20,000 to $30,000. The last time this amount was increased was 2008, when it went from $15,000 to $20,000. And anyone that has done home improvements know the costs of renovations have really increased in that time period. For background, the Maryland Home Improvement Commission administers a guarantee fund which exists to reimburse homeowners for the actual loss caused by a licensed contractor who performs a home improvement job in an unworkmanlike, incorrect, or incomplete manner, or who abandons a home improvement job. The guarantee fund is funded in part from part of the licensing fees charged to contractors when they are initially licensed and each time they renew their license. This bill would benefit homeowners who trust in the MHIC process, who have used a licensed contractor and the work hasn't gone well. With the average cost of a bathroom renovation between $12,000 and $30,000 and a kitchen renovation between $15,000 and $50,000, this bill will add protection for homeowners who choose MHIC licensed contractors. The Department of Labor reported to me that in December, the guarantee fund currently, December of 2021, had a balance of $4.4 million. And so I think this is a small increase for consumers and would be a good bill for consumers. I ask for a favorable report. Thank you.
Okay, thank you very much, ma'am. Seeing no questions, we move on to your one and only witness, Eric Johnson.
Good afternoon, Chairman Wilson and members of the committee. My name is Eric Johnson, and I'm in favor of HB 917. I contracted to build an addition on my house. There were over 20 building code violations found at a hearing. Each violation threatened the health and safety of my family and reduced the value of our home. In spite of this, the contractor sued me to force a final payment for the work. I countersued and won a judgment of $130,000 in court and spent over $150,000 in legal fees. The contractor declared bankruptcy and I got nothing. I filed with the MHIC and got a judgment of $66,000 after a 2-week OAH hearing. The MHIC Guarantee Fund awarded me only $20,000. Obviously, the $30,000 allowed in HB 917 is better, but it is still woefully inadequate. However, the problems with the MHIC go far beyond the Guarantee Fund. My contractor was cited by the EPA, the Workplace Fraud Unit, and violated numerous Maryland laws and regulations. There was sworn testimony in court that he'd said building codes are BS, and he didn't use the abbreviation. All these things were made known to the MHIC, but they have never taken any action against him. In fact, the contractor never even had to pay the $20,000 back to the Guarantee Fund that he is supposed to. And he is still licensed and operating in Maryland. So please take the time to read the written statements that I have submitted that verify my statements here today, and to find out more about this MHIC scandal and what you can do to fix it. I'm happy to talk to any of you about this at any time. Thank you for your time.
Thank you for your time, sir. I would also ask that you reach out to my office because I'd like to know what the Consumer Protection Division is doing about this and why this person is still operating inside Maryland. That is very troubling. I look forward to hearing from you as well.
Thank you.
Thank you. Move on to Delegate Valderrama, House Bill 926, for her short presentation of this bill.
Thank you, Mr. Chairman and Vice Chair. For the record, Chris Valderrama here to present House Bill 926. This was brought to me by request and happy to introduce it. This House Bill 926 is a simple technical bill dealing with the insurance requirement to sell mechanical repair contracts in the state of Maryland. So a mechanical repair contract is an optional product that a car purchaser owner can purchase to cover repairs and replacements if there's an operational or structural failure of the automobile. So the sale of mechanical repair contracts and the companies that sell them are regulated under the transportation article by the Maryland Insurance Administration, by the MIA, including a requirement that the company register with the MIA and provide proof that it carries insurance, a comprehensive liability insurance policy to ensure that claims under these contracts are paid as agreed. So current law allows only one type of comprehensive liability policy to satisfy this requirement. This legislation would add a second type of comprehensive liability policy to satisfy this requirement. The second thing this legislation would do is to allow the policy to be issued by a risk retention group properly registered with the MIA. I have a couple of panelists here who will provide additional and technical information. And so with that, I would request a favorable report on House Bill 926.
See no questions, Lance Lozano.
Good afternoon, Mr. Chairman and members of the committee. Thank you for allowing my opportunity to testify today. My name is Lance Lozano with the Service Contract Industry Council, and I'm speaking today in support of House Bill 926. Service Contract Industry Council is a national trade association whose members include manufacturers, service contract providers, administrators, retailers, offering service contracts covering motor vehicles, homes, consumer goods throughout the country. We estimate that our member companies, which include Ford Motor Company, Ally Financial, Phoenix American, Assurian, Best Buy, CNA National Warranty, and Toyota Motor Insurance Services, among others, offer over 80% of the mechanical repair contracts available in the marketplace today. Maryland House Bill 926 is legislation concerning contractual liability policies, or CLIPs, for mechanical repair providers, contract providers. These policies are the financial responsibility plumbing of a mechanical repair contract and provide certainty for consumers claiming benefits from these contracts. The bill authorizes the use of a default CLIP for mechanical repair contract providers to demonstrate their financial responsibility, in addition to a first dollar CLIP allowed under current law. The bill also authorizes the use for one or more CLIPs to back the contracts of a mechanical repair contract provider. Over 30 states in the U.S. allow for these types of financial responsibility policies. Finally, the bill also allows such policies to be issued by a risk retention group. The risk retention group is a state chartered insurance company that insures only commercial businesses against liability risks. Risk retention groups were created by the Federal Liability Risk Retention Act in 1996. We'd like to thank Delegate Valderrama for sponsoring this legislation and the Maryland Insurance Administration for their conversations regarding the subject matter contained in the bill. Thank you very much. Thank you very much, Mr. Chairman.
Thank you. Marta Harding.
Yes, good afternoon, Mr. Chairman, members of the committee. I want to say for the record, I'm Marta Harding representing the Service Contract Industry Council today in support of the bill. Again, thank you to Delegate Valderrama for introducing it. It really is a pretty technical bill. The only thing I really want to just add to what you heard from Mr. Lozano, we had conversations with the Maryland Insurance Administration about the bill before, and leading up to today's hearing. What we understand from them makes it pretty clear this bill is really more clarifying in nature than it is, at least with regard to the type of insurance policy we're talking about. What they explained to me is when they're reviewing the contract and reviewing these policies, what they look for is to make sure that there is a cut through to the insurance company in the event of a default in the payment of a claim. And as long as that's there, they really don't what the policy is called is not, or the type of policy it is not the issue for them. They will review it to make sure there's a cut through if for some reason the claim isn't paid in the first 60 days. And that will continue. This bill does not change that. So I would say the bill's really more clarifying in nature, but we do think it's an important clarification because Maryland law just isn't quite as clear as I think the industry, it would be helpful for the industry to have so they kind of know what the requirements are to do business in Maryland. So for those reasons, we would request and respectfully request a favorable report on the bill, and we'd be happy to answer any questions. Thank you.
Thank you very much. Seeing no questions, we move on to Delegate Queen 931.
Good afternoon, Chair Wilson, Vice Chair Crosby, and my colleagues in the Economic Matters Committee. HB 931, Vehicle Laws, Manufacturers and Dealers Incentives, addresses consumer concerns that I have personally encountered. As a way of background, in a pre-COVID-19 survey by Edmunds of US consumers, it showed that buying a vehicle was more stressful than getting married or going on a first date. Furthermore, 33% of the respondents said they'd rather do their taxes or sit in the middle seat of an airplane than buy a car. HB 931 views purchasing an automobile from a consumer's perspective. And here are some of the examples of what this bill addresses. To add to the stress of buying a car, when a car manufacturer's TV commercials offer a loan interest rate of 2.5% or a $500 rebate without indicating some non-credit worthiness qualifying terms, the consumer expects to get this offer. However, if the consumer obtains a loan from their credit union, let's say Navy Federal Credit Union, for a better interest rate, then goes into the dealership with check in hand, only to learn that the offer of a $500 rebate is not allowed. Furthermore, the consumer, after learning that they will not get the $500 rebate as advertised, they also learn that their desired hybrid model with the accessories and beautiful Black metallic finish prominently shown in the brochures is not available at that dealership or a dealership in the region. Yes, the dealer may offer a discount for another color or accessories, but when the consumer is paying $20K or more for a vehicle, getting your choice of a color and accessories is expected. The manufacturer's rules on automobile allocation to dealerships are an enigma to consumers and don't seem to prioritize the consumer's desires. From a consumer's perspective, these advertised rebates and incentives are a classic bait and switch that steer consumers to dealerships that cannot deliver, which only adds to the stress of buying a new car. HB 931 seeks to lessen the stress of buying new cars by considering the perspective of consumers. And so I request that you have open-mindedness as you consider a favorable recommendation for HB 931. Thank you.
Thank you. We have Rob Smith.
Hi, good afternoon. I'm Rob Smith with the Fitzgerald Automotive family. Thank you, Chairman, Vice Chair, and thank you, Delegate Queen. As she described, this bill just does two things. It adds one word to one section of the statute, the word affiliate. And the reason why is the manufacturers are hiding behind their third party, which is another entity of theirs, which is their captive finance company, to sometimes offer a rebate and sometimes not. Delegate Queen nailed it. There are times when a consumer may not qualify and the manufacturer decides that they're not going to get that $500 rebate. It's unfortunate. We actually, the one way you can tell that it's really the manufacturer is that if I get audited, it's the manufacturer that takes the money back from me, not the lender. The second part is easy. It's about transparency and the way the vehicles are distributed. It comes right out of Pennsylvania law. It's exactly the same. And it just says they have to be fair and reasonable and they have the burden of proof. It's their system. It's not prescriptive. And it just asks them to make it fair and reasonable and to make sure that we know all about it. And with that, I'll be here for questions.
Seeing no questions, I'll move to Fran Schneiderman.
Thank you, Chairman Wilson. My name is Franz Schneiderman. I'm with Consumer Auto here in support of HB 931 because we think it will help make rebates and incentives and good deals on cars more widely and fairly available to consumers, and also a better selection of vehicles available to consumers. As Rob was explaining, manufacturers have what they call these captive financing arms through which they offer financing, and they're a profit center for the manufacturers. And sometimes it's helpful for consumers to borrow through those vehicles, but not all consumers qualify for financing through those vehicles. So if you finance with your local credit union or local bank, you might end up in effect paying higher costs for the car. And these financing arms have their own idiosyncratic rules about who may qualify, and it opens up forms of discrimination against some consumers. Also, consumer advocates often urge consumers to try to arrange their financing outside the dealer network, because some high-pressure dealers, pressure consumers to add all kinds of unnecessary services and extra charges to their car loan, which can cost consumers a lot of money. So many consumer advocates think it's better to do other kinds of financing. And I think people should have to pay higher costs for that reason. Let me also say the code already says in 15207H that rebates and incentives have to be available through every dealer of the same line make. We're just adding a couple words here to add the same protection and principle to consumers. And we think that's fair and will help, more consumers get access to fair and attractive deals. So we'd ask you to consider giving a favorable report to the bill. I'd be happy to respond to any questions. Thank you.
Delegate Pippy.
I can wait till the end, but
if you want to wait till the end.
Yeah, sorry, I should have just
fine.
waited.
No, you're fine. You keep your hand up. That's fine. All right, we'll go next to Alexandra Scholl.
Thank you, Mr. Chair. Mr. Chair, members of the committee, thank you for your time. I'm Alex Shaw with Compass Government Relations, here today testifying in favor of House Bill 931. Thank you to Delegate Queen for all of her work on this bill. And, I think the delegate and other members of the panel have done a really great job in explaining it. So in an effort to be brief, I just want to reiterate 2 quick points. First, we think this bill would be great for consumers by allowing them to utilize the manufacturer's rebate regardless of the financing that they choose. It was mentioned previously, but not all folks will qualify for the financing through the manufacturer's affiliate. So we think it's only fair to allow them to utilize the same rebate that they would get if they were to finance through the affiliate, if they decide to finance through another institution. And second, this would make getting vehicles easier for consumers. It would make it easier for them to get the vehicle of their choice by requiring manufacturers, distributors, or their affiliates to have a fair and reasonable process by which they distribute vehicles. As Mr. Smith said, it will not tell them how to do that. It just tells them that it needs to be fair and reasonable. And again, this was in Pennsylvania statute. And finally, Mr. Chair, I just want to note that I do believe that we have all Maryland dealers on board for this piece of legislation. So I'm happy to say that the Dealers Association, I believe, submitted something in favor of the bill. And with that, I would request a favorable report.
Thank you, Mr. Kitzmiller.
Mr. Chairman, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchised new car and truck dealers across the state of Maryland. Here today, support and specifically the allocation section of this bill. How manufacturers allocate vehicles to their dealers is always a very important issue, never more so than right now. As most of you are aware, we are at historically low new vehicle inventory levels at this point because of the computer chip shortage. And unfortunately, it doesn't seem like it's going to change much in the foreseeable future with a lot of the factors that are going on around the world in the last week. So simply, as been said before, but I just want to hit a couple of bullet points. One, this simply says that a manufacturer has to have a fair and reasonable method for allocating vehicles among their dealers, which I'm sure they all would say that they do. Secondly, it says if a dealer feels it's not being applied to them fairly, they're allowed to request an explanation, which the manufacturer would then give them in writing. and the manufacturer would have the burden of proving that it's fair and reasonable. The fair and reasonable standard that we're talking about appears at least 4 other times in the Maryland dealer franchise law. So it's a standard that the manufacturers are complying with in many other areas in their relationship with their dealers. So with that, we would ask for a favorable report on the inventory allocation section of this bill.
Thank you very much. Now we have Mr. Joshua Fisher.
Chair, Vice Chair, members of the committee, my name is Josh Fisher here on behalf of the Alliance for Automotive Innovation. As you know, we represent the automakers. We are opposed to House Bill 931, which will likely result in the elimination of many consumer incentives or manufacturer-sponsored incentive programs for consumers. As was noted, current law requires a manufacturer to make a dealer and consumer incentives available to all dealers of the same line make, and our members do that. Every dealer in the state of the same line make is able to offer any eligible consumer the same incentive as any other dealer in the state. However, as noted, the new language requires a manufacturer and its affiliates to offer all incentives to all purchasers of vehicles, which significantly expands the scope of the requirement and means that regardless of consumer eligibility, every offer must be made equally to every consumer, which may sound good, but it raises a host of concerns. So manufacturers and dealers offer consumers a variety of incentives to spur vehicle sales. The specific details of an incentive may differ from manufacturer to manufacturer, but they do all benefit the eligible consumers. House Bill 931 threatens the elimination of these incentives because it requires a manufacturer that offers an incentive to a discrete group of consumers, such as active duty military or veterans or nurses, et cetera, to then offer that same incentive to every consumer, whether or not they match that criteria. By requiring what are really targeted and budgeted incentives to be broadly applied, the bill creates a possible need for manufacturers to drastically alter or potentially even eliminate these consumer-friendly programs. For an example, a program for a veteran could not be offered under this bill because every car buyer in Maryland is not a veteran, so they wouldn't really qualify for that incentive. So that's really our concern with this. The bill also does create an unfair competitive marketplace for captive finance companies as compared to private banks, since private banks would not be subject to any of these restrictions. Since captives provide the vast majority of rate support programs for financing and leasing, this will significantly impair competition, choice, and options available to consumers. Just one point on the allocation.
I need you to wrap it up, sir.
Yep, we just have some concerns with that. Understand it, it essentially creates the basically says the manufacturer is wrong just on a pure dealer allegation without any support. We don't really see the corresponding public benefit to that. So our real concern here is with the incentive portion of that, and would request an unfavorable report on the bill. Thank you.
Thank you very much. We have one more, Pippi, hold on. We have Paul DeBruzzi.
Yes, sir. Mr. Chairman, members of the committee, happy to be the cleanup hitter. I'm Paul DeBruzzi. I'm the counsel to General Motors. An honor to be before the committee. We do oppose House Bill 931. And with respect to the sponsor, I do note this is the second bill brought by Mr. Fitzgerald and his team, and the committee dealt with the earlier one. This is, again, a very successful, wealthy dealer who wants to bring you into what is essentially a commercial dispute between him and the automobile manufacturers. We'd respectfully suggest there's no need to become involved in that. The bill really, there are two different provisions that are really unrelated. And I want to be clear about one thing. I heard testimony that all the dealers support the entire bill. Please listen to what Mr. Kitzmiller said, who's a good man who represents the auto dealers. His group supports only the allocation portion of the bill, which is page 2, lines 10 to 20. The top part of the bill dealing with incentives is something we strongly oppose. And if you look at the current law, we go back maybe 5, 6, 7 years, Peter would remember, where the manufacturers, General Motors and others, negotiated in good faith for what's in current law dealing with incentives. We weren't that thrilled about it, but it was a compromise. And that's in the current law on incentives. It's worked well. There's no reason to add, I count 8 words, by the way, not 1, that would make significant changes to the incentive language, which the other dealers do not support. As far as the allocation language, what I object to as a lawyer, and there are lawyers on the committee, Mr. Chairman and others, the idea in the end of it where you put the burden of proof essentially on the defendant. We would have the burden of proof to show reasonableness. And that's kind of crazy. And that's the opposite of what the law provides in virtually every other circumstance with which I'm familiar. But for all those reasons, we'd urge an unfavorable report. Thank you, Mr. Chairman.
Thank you. Now we'll go to our questions. Delegate Pippy.
Thank you, Mr. Chairman. So I am figuring out there are two significant portions of this bill, and they're quite different from each other. So I'll address the first one first. One, with the incentives from the finance company, and maybe one of the proponents can help me. I would imagine the reason a finance company can give an incentive is because they make a profit if you use their financing. So for example, if I use Hyundai Financial, them holding my note, they make a profit. If they don't get my business, they don't make a profit, and hence probably why they wouldn't offer a finance incentive. And so it was brought up with military members, et cetera. So if somebody could at least address that portion of what am I missing from that component, because the idea that you would require a finance company to offer an incentive if they're not getting the business, I just have a question about that. So if somebody could help me with that.
I'll answer that. Yeah, the answer is it's really not the captive. It's actually the manufacturer. And it's a way to advertise incentives that really don't exist unless you meet that very narrow criteria, in that case of the credit eligibility. We have no contemplation of getting rid of any of the other incentives. I mean, there's been, Future Farmers of America have a rebate. Members of the military have a rebate. Recent college grads have a rebate. We don't intend to change or want to see that change. We want consumers to have every available incentive they can.
I believe his question was about the benefits offered to individuals who will use a specific type, ergo their financing. I don't believe it was to what you're not going to get rid of. I think his question was, when Hyundai gives out a loan, they also take a financial benefit, which is why Hyundai would then offer you a specific rebate for coming in using their loan system.
You have to remember that these are really one and the same. They're the same entity, the manufacturer and their captive finance company. It's kind of like a marketing arm of the manufacturer. And like I said, if I have an audit, it's the manufacturer that takes away the incentive that I passed on to the consumer. It's not the lender. So, they are one and the same entity.
That's absolutely untrue. They're separate corporate
Okay,
entities,
guys.
just to
Yep.
correct that.
And I totally understand they're separate entities. There are a lot of lawyers on here, so please don't worry about that.
Yes, sir.
I believe Delegate Pippy is on his way to becoming one as well. So go ahead, Delegate Pippy.
All right. So the second part, and I appreciate Smith, similar corporations, different, or similar owners, different corporations. The second part's the allocation. Now, as I understand, the allocation to dealerships, I would assume, is based on need or based on whether they're selling cars or how many cars they have in the lot. And so I'm just curious, what are you getting at, or what's the proponent of the bill or the bill sponsor here getting at with having the allocation sent equally? Is there a situation where the manufacturers are, punishing, maybe that's not the right word, but they're not giving dealers inventory when they need them? If you could help maybe the committee with understanding that piece.
That's certainly part of the reason why we want to know and want that transparency, so they will explain that. Right now, as Mr. Kitzmiller described, there's a shortage of vehicles because of the chip problem. And I liken it to being in a NASCAR race where we're all on yellow. So everyone should be reduced by around the same amount. It is a turn and earn system. I'm certain of that. They all describe, but maybe they could just be more transparent and be like they are in Pennsylvania. Again, the statute exists in not just Pennsylvania, but I'm sure other states, but this is the exact language from there, so that they can provide that information and explain it and show that it's fair. Again, it's not prescriptive, doesn't tell them how to do it, doesn't say everyone has to get the same amount. That wouldn't make sense, because some dealers sell a lot more vehicles because of the population area that they're in. But it does have to be reasonable and fair. That's all it says.
So the issue is that they have a discretion, and the dealers are not privy to that discretion or understanding. I use the Corvette as an example. There's only so many Corvettes that were made. The Chevy gets to decide who gets the Corvettes, and there's big markups on them and whatnot. So is the issue that the dealers have no idea how the the allocation is calculated and they're not privy to, there's no remedy, there's no process where they can say, hey, why aren't we getting these? Is that part of
That's correct. In fact, some of them right now, they just flat out admit they have no system. I mean, there was a recent meeting of a manufacturer and they just said, we just don't have a system. So we're curious how that can possibly be.
Okay, thank you.
And I would ask to specify your questions when you can. So Mr. Adams, Delegate Adams.
Thank you, Chair. And Franz, I guess the question's for you. And anytime we have these bills, I ask the same question. A car purchase is a negotiation that involves, I think, three steps. It's the price of the vehicle, it's the rate of interest should you have to borrow money to buy it, and then it's the value of trade that goes in that. Anytime that I've seen bills like this that come in play, they take away the consumer's expectation of what a negotiation looks like they're trusting the state to do the work for them, and that's just not how the negotiation is played. I think that there's a consumer advocate, if that's your industry's position, it should be to inform the buyer of how a negotiation works and treat each of these independently. Would you agree with that, or would you not?
Well, Delegate Adams, I mean, I guess what I'd say is I don't think we're interfering with the possibility of negotiation. The consumer is still going to be negotiating with the dealer representative over all kinds of terms about the sale of the vehicle and the price and so forth. We're just extending the body that we already have of regulations that provide certain guidelines and guideposts to make sure that the negotiations are conducted under fair ground rules. I mean, we already have, as you've probably heard me say before, an extensive series of regulations about this to protect both dealers and the consumers who, frankly, don't know nearly as much about the products they're buying or the whole process as the manufacturers.
But that's what I mean, Franz. If you don't mind, I'll just close by saying that should be your, if you're the consumer advocate, that should be your first and foremost goal, is to make sure consumers understand negotiation. And I'm sorry, Mr. Chairman, the only thing I'm saying is that these bills continue coming in and asking the government to get in the middle of these, not only the franchise and the dealer, but now it's the buyer and the dealer. And
I understand.
It creates a problem in my mind.
Yes, sir. Thank you very much. We have last question, Delegate Queen.
Thank you, Mr. Chairman. I think I want to just make a clarifying statement, but I'll ask as a question and just to answer some of the comments that were made. One for Delegate just spoke. This issue that I'm talking about is related to having fair negotiations. And I'm talking about an incident that happened in 2008. This is pre-COVID, that has been properly exacerbated with COVID and the limitations on models. But I went to seek to purchase a Prius just because of all the mileage that I put on my car because of coming to here every year. And I waited until December, when Toyota always has its offer of the Toyota, sell-a-thon, when they're offering a rate and a rebate. They do it every year. I waited for that. And so they offered a 2.5% interest rate or a $500 rebate. They said nothing about having to use their financing. I am a member as a wife of a career veteran of Navy Federal Credit Union. We went in and negotiated a cheaper rate at the Navy Federal Credit Union. I went into the dealership, check in hand, after making several calls to several dealers in the area about what the price of the car would be, what the features I would have. I had to call about 4 dealerships in this area to get the model that I wanted. One, because they all didn't have the model and the color that I wanted. They had to get it from, I think, which they call another region in Virginia. I found one dealership who was willing to do that for me and not charge me for that. And I went in and with check in hand, minus the $500, basically thinking I would get that rebate because it didn't say it was an or, and it didn't say I had to use their financing. And so I'm not talking about taking incentives away from veterans. And I've talked to the manufacturer about that. That's a clear sort of class of people if you want to offer rebates to, that's fine. I'm not saying we should, that has to be offered to all. I'm not saying you have to give special incentives to first-time college buyers or those have to be offered to all. I'm talking about something that is advertised that anyone can have 2.5% interest rate or a rebate, and it was not offered. I had to use their finance company to do that. And so that needs to be said up front if that's the case. And so I'm not wasting my time spending a lot of hours trying to negotiate and doing the job that an informed consumer should do, which I understand. But when I take my husband into the dealership to say, you got to go with me today because I'm buying a car, we don't want to be playing around. He doesn't like to be played around. And so we need to buy the car. I need to be ready to buy the car. And I expect that dealer to give me what I talked about and negotiated over the phone. Isn't that stuff?
Thank you very much. I appreciate that. I believe that is the last witness we have on this case.
Thank you.
We'll go on to the next bill, bill. Next bill and our last bill and our large bill for today. Delegate Foley, 934.
Thank you, Chair Wilson and the honorable members of the Economic Matters Committee. And I think my staff called and asked if I could get screen sharing as part of this presentation. So if screen sharing for me could be enabled, I'd really appreciate it. Thanks very much. For the record, I'm Delegate Linda Foley, and I'm presenting HB 934, which would ban the sale of gas-powered leaf blowers in 2024, and then ban their use in 2025. Also under this bill, retailers selling gas-powered leaf blowers would need to post signage letting buyers know of the changes in this law or the changes that this law would affect. There is a sponsor amendment that I'm putting in that will allow local governments to create stricter standards if they so choose. And I also will be proposing an amendment that will exempt firefighters from the ban of use in line with requests from the Maryland State Firemen's Association, because we certainly don't want to interfere with the firefighters' ability to fight fires. We also are in discussions with some opponents of the bill to explore other potential amendments. So this bill is modeled after a law in the District of Columbia. That law went into effect on January 1st of this year. And ever since then, my constituents have been me with requests to ban these gasoline-powered leaf blowers as well. This bill is aimed at reducing the micro and acute health impacts of the gas-powered leaf blowers. It is a widely established fact that being around loud noise, especially noises with low frequencies, as these gas-powered leaf blowers emit, causes ear damage, hypertension, and can also cause heart disease. Workers who use these machines, many from brown and Black communities, are being put in dangerous situations that are detrimental to their health. Beyond the noise, these devices emit severely toxic fumes. That's because they're two-stroke engines, which emit very toxic fossil fuels. Birds, frogs, and other creatures are repelled by the noise, while plant life and pollinators are likely to be disrupted by the force and heat of these gasoline-powered blowers. Legislatures around the country have been enacting laws that ban the sale and use of these dirty, inefficient, noisy, and annoying products. In Maryland, the Chevy Chase Village, the town of Somerset, and the town of Chevy Chase have already banned them. And as I mentioned, in DC, they are also banned. Additionally, 170 cities and states have taken this step to ban gas-powered leaf blowers. And recently, California passed a statewide ban on the sale of all off-road two-stroke engines, and that includes gasoline-powered leaf blowers. So now, if my screen sharing is enabled, and you'll indulge me, I would like to demonstrate what I'm talking about in terms of the noise. So I hope everyone can see that. All right, first, this is a gasoline powered leaf blower. Okay, next, we're going to hear a battery powered leaf blower at 65 decibels. You'll hear the difference. Much less annoying. Now a gasoline powered leaf blower at the same decibel as the battery powered one. So I think that what that little demonstration shows, and I think what you can find in your own life if you've heard these things, is that gasoline powered sound from those gasoline powered leaf blowers is very unique, and it is much more annoying and piercing than the sound from the electric blowers. We're going to hear more from Chuck Elkins, who's one of the witnesses here on this issue. But I just want to conclude by saying that these machines do more harm than good. And I also want to note that in the fiscal note, it says that if this bill were to pass, that the state of Maryland would actually save money in the long run because we would save on the cost of fuel. So as a result of this and everything I've talked about and what you'll hear about from the witnesses, I urge you to join the wave sweeping our nation and finally blow away these noisy, annoying, and harmful gasoline-powered leaf blowers. I urge a favorable report on HB 934. Thank you very much.
And before we go to our witnesses, I would just want to say, I know that you mentioned the Black and brown workers, as so many people in the State House tend to do, but I would like to point out that not every Black and brown person is a worker, and many of them actually own their own companies. All the ones that I know actually own their own companies. That's what they start doing. And this isn't at an expense to them. They're not just workers, they're actually owners. So whenever we do pass these bills to save my people, we also are sometimes hurting my people. So I'm just making that clear because I hear every day about Black and brown people and our workers, but we're also business owners. And that's a great way for a lot of the young folks to get started, is in that business of lawn care. I know plenty of young foster kids that I work with that are doing that right now. We'll go to the next slide. The first question is going to, our first presenter is Marie Laporte.
Good afternoon, Chairman Wilson and committee members. My name is Marie Laporte. I'm a resident of Reisterstown and a member of the Chestnut Woods Homeowners Association, speaking in support of HB 934. Over the 23 years that I've lived in my community, the usage of leaf blowers has grown significantly. A device that was once limited to assisting leaf collection has replaced rakes, brooms, and even shovels during a recent snow. During the pandemic, the noise they generate was the #1 complaint of residents, many of whom now work from home. Business works in the suburbs. I was surprised to learn that gas-powered blowers typically generate enough noise to cause hearing damage, not just for the operator, but to people, including children, and the next yard, and the next yard beyond that. Further, gas leaf blowers produce as much pollutants in 1 hour as driving a Toyota sedan 1,100 miles, according to a 2020 California Air Resources Board study. Using that one leaf blower for less than 13 hours produces as much pollution as an average car driver in Maryland in a year. A typical residential user uses a blower an average of 10 hours annually, while a commercial user uses it 282 hours, putting out the equivalent annual pollution of as 23 cars for each blower. The life of these blowers is short, 3 to 5 years, and they are inexpensive, with an average price of about $200, which is nothing compared to the environmental cost. In California, a state known for cars and traffic, mowers and blowers and the like now produce more smog than passenger vehicles. Sit with that for a second. Stunning. It's little wonder that states and municipalities from California to Mountain Brook, Alabama, have moved away from these devices. They are absurd polluters, doing outsized damage to the environment and harming workers and the general public. The electric ones are powerful, clean, quieter, and affordable. For these reasons, I respectfully request a favorable report on HB 934. Thank you.
Thank you, ma'am. Delegate Queen, did you have a question? Okay, we'll go on to Shruti Bhatnagar.
Yes, thank you so much, Chairman, and good afternoon to all the committee members. My name is Shruti Bhatnagar, and I'm the chair of the Sierra Club Montgomery County Group. I'm testifying today on behalf of Sierra Club Maryland. You've heard some compelling reasons from Delegate Foley and from Marie Laporte. I will not go into all the details that have already been shared, but I would like to reiterate that the types of emissions in leaf blower exhaust have been linked in other settings to a variety of adverse health effects. These include cardiovascular disease, stroke, respiratory disease, lymphomas, leukemias, and other types of cancers. Neurological disorders, including autism, premature death, and effects on prenatal development. The noise from the gas-powered leaf blowers is harmful to the well-being of humans and the existence of other species, such as birds, frogs, and other creatures that may be forced to move away. Plant life and pollinators are likely to be disrupted by their force and heat. Most gas leaf blowers impact the operator's ears at 100 decibels or more. And according to the Centers for Disease Control and Prevention, exposure to 100 decibels for just 15 minutes a day can lead to hearing loss. Further details are shared in our written testimony. We urge a favorable report on HB 934. Thank you so much.
Thank you. Delegate Brooks.
Yeah, thanks, Mr. Vice Chair. Yeah, I just had a question for Ms. Marie Laporte. You live in Reisterstown. I think you're my constituent. Quick question. Yes. On the you were saying the useful life of a gas blower is what, between 3 and 5 years?
Yes.
And, yeah. Okay. And so I'm thinking if a person has one, and this bill will say terminate any type of usage after January 2025. Why not allow that unit to exhaust its useful life instead of mandating that the unit can't be used anymore? Because I mean, $225, a good gas blower probably cost you about $250 to $275. So, or is there anything in I didn't see anything in the bill that would offer any compensation to the people who owns that equipment? And the other question, if I can do a part 2 on that question too, have you considered businesses, landscaping type entities, and what that cost would be to them to just abruptly just terminate, shut off that ability to use it within a year's time?
Mr. Chair, maybe I can answer some of Delegate Brooks's question.
Go ahead, Delegate Foley, but real quick to everybody, just a reminder, the chat is for members only. Go ahead, Delegate Foley.
Thank you, Mr. Chairman, and thank you, Delegate Brooks, for those questions.
Yeah.
In terms of just saying as the sponsor of the bill, we believe that these devices are harmful, as has been pointed out by some of the witnesses, and I think more of the witnesses will also talk about that, to both humans and the environment. And so our interest is to phase away from them. So just saying as the sponsor of the bill, and as I mentioned, I'm talking to some of the opponents of the bill. And one thing we have talked about is spreading that timeline out so that the inventory can be used up on some of these devices. And then your second question, if I might, and then Ms. Laporte can weigh in if she wants to, is that we also did consider some sort of rebate program and would consider that. That, of course, would, cost money and would mean that we would have to find as a state a way to do that. But that is something that has been considered in other jurisdictions, and it's probably something worth looking at here as well.
Okay, yeah, and quickly, Mr. Vice Chair, yeah, I've got a gasoline powered, and then I went and purchased a battery powered And I love the battery power. You're absolutely right. It's a heck of a lot quieter. And then I don't have to take in all of those fumes. So that was my inspiration, but I'm just concerned about, I was just really concerned about the businesses who utilize that type of equipment, and that for them to have to fall off a cliff, So thanks. Thanks, Mr. Vice Chair.
May I clarify that data point? For Delegate Brooks. So that information came from the California Air Resources Board study on those particular models. The 3 years pertain to commercial users, 5 years was for homeowners.
Okay, thank you.
Thank you, Delegate Adams.
To the sponsor of the bill, if it passes, what are we to do with the gas-powered equipment? Take it to the landfill?
Well, the gas-powered equipment, I would hope that you would dispose of it in a, in an environmentally sound way. But the point is that you wouldn't be able to use it anymore. And so again, we are talking to some of the opponents of this legislation about this very issue of what is the phase out period, because the gas-powered blowers they will give out at some point.
Mr. Vice Chair, can I ask a follow-up? Do we know how many of these gas blowers are in the state of Maryland right now? Any guesstimate?
I do not. I don't know whether some of my witnesses who are testifying might. I don't have that information. I could get it for you though. Well, I could try to get you the information if you want.
It has to be measured in millions, but that's neither here nor there. Thank you.
Okay, Delegate Fisher.
Thank you.
Delegate Fisher, you're still on mute. I know you run a podcast, but you have to unmute yourself.
Thank you, Mr. Vice Chairman. I appreciate that. It remuted. So my question is for the sponsor. So I just want to make sure it does say a person may not use a gasoline powered leaf blower in the state. And I know someone's kind of asked us before, but I just want to make sure. So if you have one already after 2025, you can't use it, right?
Yes, Delegate. Thank you for that question. Yes, the answer to that is yes. And but as I have said, we certainly are open to pushing that timeline out.
Got it. And why are firefighters exempted?
I'll let the firefighters talk about. I mean, I think there's someone testifying from the Firemen's Association.
No, I understand that, but I'm asking you.
My understanding is that that they need this equipment with the additional extra power to fight fires. That's my understanding.
Okay. How about landscapers? Do they need the extra power as well?
I'm not a landscaper. There are landscapers who are testifying in this hearing, and perhaps you can ask them, Delegate Fisher. My opinion is that they don't, but I'm not a landscaper, so I just want to be clear.
Is this the law already in Montgomery County as a county, or is it just a few localities?
It is not the law in Montgomery County currently. I know that Montgomery County is looking at passing this law. It is the law in the District of Columbia, and it is the law in the towns that I cited, the municipalities that I cited.
Sure. So I guess if you have a golf course, you can't use them on the golf course either, if you're a golf course owner or a golf course maintenance company?
If this bill were to pass, that would be correct. Yes, Delegate.
Okay. And so Montgomery County is very different from Calvert County. Why is this a statewide bill? My county is entirely different from yours. Yours is urban and crowded and quite frankly, a royal pain to drive through because the roads are always clogged. My county is beautiful and open, and we've been really great at land preservation. And we have a pretty substantial farming community and people that really love to play in the open spaces. We've done a lot of work for that, and they use leaf blowers. I mean, why do you think that why do you think that it's appropriate for you to tell the people in my county that they can't use property that they already own?
Well, Delegate Fisher, that's not the point. Is it telling them to use property?
But that's what the bill's doing.
Oh, you mean in terms of the leaf blower? Yes. Okay. So
what else would I be talking about?
First, Delegate Fisher, I do.
I mean, I'm talking about your bill.
Delegate Fisher, I do want to say that as a Montgomery County resident for more than 30 years, there are many beautiful parts of Montgomery County also. And I love living in Montgomery County, and I have been to your county, and yes, it is beautiful, but so is Montgomery County. And I think that if there were not an alternative to replace these devices, I would say that, that would be the case, that, we do need to use blowers in some cases, but the electric alternatives are substantial and are good enough for places like golf courses and others. And I have some witnesses who are testifying who will testify to that.
No, I hear you. So Delegate Foley, how about hair dryers? They're really loud. My wife uses one. It's extraordinarily loud. Why don't you have a bill to ban those?
Well, I don't think there are any gas powered
That's correct.
dryers.
But I think one of the
possibly, but now that
understood, but part of the testimony here that has been given by the delegate herself and others is that the leaf blowers are loud. So are hair dryers, so are blenders, so are garbage disposals. They're loud.
Mr. Chairman, I think I can answer that if you permit me.
Quickly, please.
Yes, thank you. In the case of the devices that you cited, I haven't done the same kind of research on hair dryers and garbage disposals, but I will say this, that a gasoline powered leaf blower, and the slides that I put up show this, that sound travels not just in your house, which is what a hair dryer is, or maybe just in your bedroom, which is where a hair dryer is, but that sound, because of the fact that it's also such a low frequency sound, travels across many houses. So you can be heard 23 houses away. It can penetrate walls and it can penetrate windows. So it's not just you who are affected by it or you who are in your bedroom who are affected by it, but it's also your neighbors in your neighborhood and anybody else that's around. So that's a long way of answering your question, Delegate Fisher.
So does your bill have a blower buyback program, like a leaf blower buyback program where you can get to pay people for the expropriation of their property because they can no longer use it? Because that's effectively what the bill's doing.
Delegate Fisher, as I said in answer to Delegate Brooks's question, this bill does not have a buyback program. I certainly would be open to that. I think many of the places that have passed legislation like this do have buyback programs. Some of them don't. And that would be something to look at. I think that would require, some additional outlays of money. So, so I certainly would be open to a buyback program.
And lastly, I would just say, I would suggest that, and I'm well aware of Montgomery County having an outer tier that is somewhat rural. Obviously, Carroll County, in Calvert County, of course, we have a substantial rural inner tier from the beginning to almost the end. And I suspect maybe that's why your county hasn't passed a countywide ordinance, because people in different parts of the county and people in different parts of the state live differently. And that's a good thing. And I really think that that's my point in asking this question of why you guys haven't passed the ban. It just seems, that when you have people living in different ways and they choose to do so, my neighbor has a farm. I can barely hear what they're doing over there. Yet your bill would apply to them as well. And I'm just not really sure that one size fits all. Go ahead, you can comment.
Well, I think Delegate Fisher, we talked about this already, but I think you will hear that Montgomery County is on the verge of passing this legislation.
Oh, I'm sure they are. I'm not surprised at all, but I'm sure they are.
And I would just add that the agricultural reserve in Montgomery County that you referenced is actually in my district. And the people of my district support this, including people in the agricultural reserve. So,
well, we all can find people that support things. Question is, do the various local communities? In any event, I know we're debating the bill. I appreciate you answering my questions. Thank you, Delegate.
Thank you for the questions.
Thank you. And I'm glad we established all of Maryland is beautiful. Delegate Pippy.
Thank you, Mr. Vice Chair. I guess this would be a question for Delegate Foley. And it's kind of alluded to before. The bill is it's somewhat dramatic. So I'm going to try to attack each point. You mentioned the issue of noise. Now, typically, a local municipality or a local authority would govern noise ordinances. And look, I mean, if you lived in, let's say, a townhome community and you had a small patch of yard in front and you're operating an old school gas powered leaf blower, I mean, you know, why wouldn't it be more appropriate for a local municipality to structure when and where and who and why could use a loud piece of machinery depending on the population density? Because as it was alluded to earlier, you know, some jurisdictions like mine are predominantly rural, you know, and the argument that we're doing this for our ears, which, you know, I feel like cannot be the real reason why we're talking about this bill, but that you brought it up, we'll address it. I don't think that would be appropriate for a statewide bill, particularly because a lot of people live on, you know, like in my district, they have large plots of land. They don't have neighbors next door. There may be no children at all nearby, and people may be using ear protection. So you could have a scenario where a guy has earplugs, no one's around, and there is no threat to physical, you know, their physical ear or hearing and such. And so it seems more like this has to do with the environment, which I understand that. The problem is that, you know, you've got a society that is you know, more or less built itself on combustion engines, and it's quite impractical to just completely ban something without first offering other solutions, maybe incentives, maybe coming up with a way to offer something creative for people to diversify into more electric equipment. There has to be 1,000 other things we could do rather than just banning arguably the most common piece of equipment that people have. And I think that's why you're getting a lot of pushback from committee members here based on the somewhat impracticability of a proposal like this. And so my only, you know, question, I guess, and I'll end with this is, you know, did you explore some of those other options first before putting in, you know, essentially banning fire? You know, if you could help me with that.
Well, thank you, Delegate, for the question. I don't understand the banning fire, but I think—
Well, that's what a combustion engine is. It's fire.
I see. Okay, so I understand but I do understand your larger point. So in terms of this, yes, you are correct. It is bad for the environment. And just as we, you know, ban other products that are bad for the environment, and I know, you know, from a rural community, you certainly understand that we ban some other products that are used in rural communities, you know, pesticides and other things that are bad for the environment, that this is another product that's bad for the environment. So the answer to your question is that, you know, that's the reason to stop using these dirty and, you know, and unhealthful devices. So that, you know,
I will point out that we do have exemptions for certain pesticides, particularly for folks that grow fruit, like in my district, although that may not be as prevalent in, let's say, Montgomery County. But, you know, when you ban certain, so anyways, not to deviate a little bit, the bill is very specific, but it has very broad implications. And so my only thought was there any effort put into kind of coming up with some alternative ways to get people off of the gas powered blowers? And I haven't heard that from you specifically, but
yes. Well, Delegate, if I could also follow up and just point out that there is an alternative, and that is battery powered electric leaf blowers, and that's the alternative.
Thank you.
Okay, I have been.
Right, thank you, Delegate Mounts.
Let's see.
And quickly,
Hey, thanks, Chairman.
yeah, well, hold on real quick, Delegate Mounts. Staff, can you make me host? Oh, there you go. Delegate Branch is muted. Go ahead, Delegate Mounts.
Oh, thanks, Chairman. I think my question is for the well, actually, the sponsor is still here. Why is this bill just limited to leaf blowers? There's so many other types of two-cycle engines that make noise, loud noise. Well, I mean, why is it leaf blowers?
Thank you, Delegate, for that question. And I would like to make it broader than that, actually, if you're asking me, but I think that, we start with leaf blowers that because they seem to be less
You would-
common than other types of devices like lawnmowers.
Lawnmowers.
But I would like, as an environmentalist myself, I would like to get to the point where we do ban two-stroke engines. And in California, they have banned the sale of all two-stroke engines.
That's
So-
what I was getting. I was just going to get at that. I was like, so you would support banning the chainsaws, lawnmowers, outboard engines, all that stuff.
Well, I don't.
I mean,
Personally, I think that two-stroke engines have problems because I think that they're dirty. They're inherently dirty. Whether I would ban them all, I can't. I'm not qualified to speak to that. And my only point is that I think that these leaf blowers not only have the problem of the toxic fumes that they emit, but there's also the noise factor, which some of those devices and engines that you cited do not have the same level of noise and the same problem with the noise.
But thank you, because you answered my question. This is basically a two-cycle across the board engine approach bill. But I have my substantive question is specifically about the bill. The testimony we just received was for the Sierra Club. And is that witness still on the call, the Sierra Club? Because Mr. Vice Chairman, is she there?
Yeah, Delegate Mounts, I do not see any of these witnesses signed up for the Sierra Club.
Oh, really?
We've only had two go. One was a private individual. The other is from an organization called Chestnut Woods.
Oh,
Were you looking for Ms. Laporte? Or
one of the witnesses testified about the illnesses that were linked to leaf blowers. And I was just hoping, ask if she could repeat those, because I heard them, but I didn't quite get them all.
Mr. Chairman, Mr. Vice Chair, I think Shruti Bhatnagar was from the Sierra Club. I don't know.
Oh,
whether she's
my
still on the
apologies.
call.
I just didn't see.
Yeah.
Okay, Ms. Bhatnagar, go ahead. Are you still here?
Because I think she said.
I think she left, Delegate Mount. So I'm sorry.
Thank you.
Yep. Okay, we'll go to Delegate Arentz.
Thank you, Mr. Vice Chair. This is for the sponsor. I guess I understand what you're talking about. I think if I do a little bit of home improvement, I do some things, and I think the market's taking care of some of your concern with electric equipment as far as change laws and what. But you made a statement about a leaf blower produces more problems for the environment than than an electric car. Are you talking, I mean, I find that very difficult to believe. Building an electric car and the batteries and all that's in there doesn't create a bigger footprint against the environment than a leaf blower being used for 20 years. Where's that data? Do you have that data on what it takes?
Thank you, Delegate. I'm not sure I understand what data.
You made the comment about an electric car. You said that. You said that it pollutes more than an electric vehicle. Isn't that right?
Delegate Arentz, I didn't say that. I don't know. Maybe one of the witnesses said that, but I did not say that.
Well, I thought you had mentioned something about.
No, I did not mention electric cars, sir.
Okay. Then my mistake. I just say my bottom line is when I work, I also use vacuum cleaners, commercial shop vacs. They're worse than any leaf blower I've ever used. And again, I think we're looking at something here, the apples and oranges of something. And I understand your comment, but I think the comments, maybe you didn't make them, but about how often we use them and what we do them, I think they're grossly misrepresented in the sense that this is a vast majority. Like Delegate Fisher, I live in, I think over 60% of my county is farmland. That's huge. And I don't know that how this thing would affect us because we have different ways of handling our messes, if you will, from leaves to everything else. I just think I dig into this bill a lot. There's a lot to it. You've hit on several areas as far as noise, as far as pollution, whatever. I try to look to maybe fine tune the bill if at all possible. But thank you. It's an interesting bill.
Okay, thank you. We'll go to Delegate Chitty.
Thank you, Mr. Vice Chair. First of all, welcome to ECM, my district colleague, Delegate Foley. So, Mr. Vice Chair, I just have a technical question. I can save my question if there are more witnesses, because this is one particular question related to one of the testimonies I read among the.
Delegate Chitty, we have 14 more witnesses.
Okay, I can wait. Thank you.
Okay, Delegate Watson.
Thank you, Mr. Chair. I would like to ask the sponsor about the toxic fumes comment that you made. Do you have data or, for example, have we had workers' compensation claims where employees are sickened from the fumes of the leaf blowers? Do we have any data or anything on that?
Well, I have a witness, Mr. Elkins from the Environmental Protection Agency, who I think may talk something about that.
Okay.
In terms of the data from the fumes, I mean, we have focused on the noise, but in terms of the toxic fumes, there have been studies done to show, and I think one of the witnesses did, it might have been Ms. Laporte, commented on the amount of toxicity that goes into the air, and maybe she can comment, she can repeat.
Okay, thank you for that. That would be helpful if you find any more information on that. Second question very quickly is the battery issue with electric leaf blowers. Do we have, or is there data that shows we can handle the battery disposal and the battery waste that comes from switching from gas to electric?
Well, that's a good question, Delegate Watson, and thank you for that. I think the disposal of these batteries that we're using is an issue for us across the board, including, with these cell phones, right? So I think that, in the committee that I sit on, Economic Matters, we're looking at that. I'm sorry, this is Economic Matters. The committee I sit on, Environment and Transportation, we are looking at those issues. Yes, I mean,
Okay.
absolutely. We have
Thank you. One comment that I want to make is that, you keep saying leaf blowers, and that's how we know this piece of equipment. But nowadays, it's also grass clipping. So every single time the grass is cut, and landscapers that operate in my area are using the leaf blower just to sweep the grass off of the driveway. And I just want to remind the people that might be watching and that you can also advocate for homeowners associations, your own homeowners association, if you're contracting with landscapers, to ask them not to use the gas blower. But in general, I think we need a system where you would transition this rather than have it be cold turkey next year. Thank you very much.
Thank you, Delegate Watson. We're going to continue to go on. It's Priya DeSamara. Did I say that correctly? I know I saw you in here.
She's here.
Muted? Okay.
There you
No,
go.
it's Priya DeSarma. But thank you, Chair Watson, Vice Chair Crosby, and members of the Economic Matters Committee, and Delegate Foley for being the lead sponsor on House Bill 934. Starting when I was home taking care of small children, trying to make them nap, and all the way through the COVID pandemic, when I, like many others, have worked from home, I've been disturbed by the noise and smell of the leaf blowers and other lawn equipment. But the noise and smell are more than an annoyance. Our family in Ellicott City drives an electric vehicle, uses renewable energy, and is fortunate enough to have convinced the neighbor who mows our lawn to switch to an electric mower. So on a personal level, we're doing what we can. According to the EPA, lawn care industry in the United States produces 13 billion pounds of toxic pollutants per year. Running a gas-powered leaf blower for 1 hour emits the same amount of pollution as driving a gasoline car for over 1,000 miles, as was mentioned. And in addition, large leaf blowers can be heard 91 houses away from a unit versus the hair blower someone was asking about, which is only 10 to 30 decibels. That is at a much higher volume. Think of the workers who have to work with these machines all week, inhaling formaldehyde, VOCs, nitrogen oxides, carbon monoxide, benzene, and particulate matter, deal with constant machine vibration, and are exposed to 115 decibels of noise in their ears, well above the 85 decibel threshold that results in permanent hearing loss in as little as 2 hours. Electric blowers have been found to be equally or even more efficient by the Consumer Report, are lighter and quieter, and have zero emissions. Please see more in my written testimony. Banning gasoline blowers will prevent premature deaths, cancer, heart and respiratory ailments, osteoporosis, dementia, stroke, reproductive issues, preterm and low birth weight, and birth defects. Consider the economic impact given your committee. Workers' compensation, sick days, shortened work life, and thereby taxable years, and treatment costs. and the demand for the electric lawn and garden equipment is forecast to increase to 14 billion by 2024 by the Fredonia Group. I think Maryland should definitely tap into this market and incentivize, as you suggested, consumer switches to electric. If you care about the citizens of this land, both rural and urban, and the land that you represent, I ask that you find a favorable report for HB 934, join Hawaii and over 200 localities. As was mentioned, a broader version has already been passed into law into California, Assembly Bill 1146, which includes incentives. So does the one that's in process as of recently in Colorado, Senate Bill 138, and Massachusetts and Illinois. Surely Maryland wants to be at the leading edge of this effort. The cost of inaction is greater than the cost of action long-term as well. Please act now and support House Bill 934, which is but a small step in the right direction. Thank you.
Thank you. Barton Rubenstein.
Oh, hi. Thank you, Mr. Chairman, for the time. And my name is Bart Rubenstein. I'm the chair of the Environment Committee of the town of Somerset in Chevy Chase. I'd like to start with a quote from an ENT specialist, Dr. Myers, quoted in the Atlantic. Each time I see these landscaper crews, I think to myself, 10 years from now, they'll be on the path to premature deafness. As you may know, our town put in place a ban of gas-powered leaf blowers starting on September 1 of this year. This piggybacks the work of Washington, D.C.'s ban, which began on January 1, as well as that of in Chevy Chase Village, which also began this year. The key word here is piggyback. This means that the state of Maryland doesn't need to do any homework on this bill because Washington, D.C. has already done it. And in fact, D.C. was inspired by the ban in the whole state of Hawaii, as well as hundreds of communities around the nation, which have also banned these horrible machines. Even California is about to start this ban. So this bill is actually an easy bill because it is merely piggybacking successful legislation around the nation on something that is widely known to be a major hazard. As I hope you already know, gas-powered leaf blowers have been shown by a plethora of scientific evidence to be hazardous to the quality of life on many levels, mostly related to the penetrating low-frequency loud sounds that pass through houses, like the heavy beat of a hard rock concert. This bill is about quality of life and health of its residents, but it is also about the landscapers, mainly from the underserved communities, who have no idea of the health threats that they are exposed to every day. Last, our town of Somerset has run a very successful campaign of educating our neighbors about these hazards, as well as how to begin more sustainable gardening practices, such as not blowing leaves off grass, but rather mowing them into the grass and creating free mulch. Even with the ban starting in 6 months' time, our neighborhood is already quieter and neighbors are happier. And Mr. Chairman, I'd just like to answer a question which was brought up. I just would like to say that in response to a delegate's question, because the ban is already in place here in our neighboring DC and also a couple municipalities in Maryland, many landscapers have already made this transition. So this is already happening. Whether or not the state decides to move now or in a couple of years' time, landscapers are already making this transition. Please. So I urge the state of Maryland to consider this ban of the horrible machines with House Bill 934. Thank you.
Thank you. Just a reminder to all the witnesses, you get 2 minutes. Next, we have Nancy Seinberg.
Hi, my name is Nancy Seinberg, and I'm the owner of The Enchanted Garden, a landscaping company that's been in business for over 30 years. We converted all of our gas-powered equipment in 2016 to electric battery-operated power. And when we first did it, my crew was a little bit reluctant, and was this going to be powerful enough to accomplish the tasks? And after a few months, they never looked back. They never asked for the gas blowers again. And they were very, very happy to be using the electric battery operated equipment. So we've been using it for almost 6 years now, and they all seem to think that they're healthier. They are definitely happier, and they report that they have much less time out because of illnesses. They all seem to feel that they've had much less sick days because of it. I don't think they're any less powerful, and I think everybody's happy not to be strapping a 2-stroke engine onto their backs every day, coming home smelling like gasoline. My clients also seem really happy with it. They seem very supportive not to be hearing the noise, and that the workers just seem much happier. We wouldn't go back. And over the 6 years, I would say the equipment has gotten much, much better and the quality's become much higher. And the initial cost, it is an outlay, but I would say overall what we spend by not buying gas and not repairing the other equipment, it's definitely a savings in the long run. That's it. Thank you very much. And I'm in support of this bill.
Thank you. Roy Sewall.
Hello, can you hear me?
Yes, sir. I got you. Go ahead.
Okay, thank you. Appreciate the opportunity to speak as a private citizen today. I'm a 53-year resident of Bethesda. I've lived for 45 years in the tiny town of Oakmont, across Old Georgetown Road from NIH. There are about 60 homes in our town. I chair the Electric Lawn Equipment Committee, and we've done a lot of research into gas leaf blowers in cooperation with some of the other people on this call today. Although today I'm speaking as a private citizen, and granted I have a Montgomery County perspective, this is a suburban neighborhood. Although I would love to address the generic range of severe health, noise, and social justice issues related to gas leaf blowers, I think that's been covered today. I'm going to restrict my comments to the impact on people working from home. So most homes in Oakmont are owned by professional workers, many of whom are working from home. My wife and I are examples. We all know that working at home is a major result of the pandemic and are not likely to disappear in the future, in the foreseeable future. Noise from gas leaf blowers causes immense disruption to our ability to work from home, to concentrate, to conduct video conference calls, to have phone conversations, the very essence of our business. There are over a dozen homes here that use GLB contractors. When the house across the street has two GLBs working simultaneously, the sound in our house is totally disruptive to any business activity for 1 to 2 hours. And then other GLBs in the neighborhood will fire up during the day. GLB contractors are generally hired by neighbors who are not working at home, so they don't appreciate the havoc that is being caused. But from my perspective, people are coming into my neighborhood and disrupting my neighborhood, and there's just a lack of fairness of
Sir,
that.
I'm going to need you to wrap up, please.
I beg your pardon?
I'm going to need you to wrap up, please.
Okay, please imagine your office is being barraged by GLB sounds during the working hours. And I just want to say, in a wealthy, progressive state like ours, it's unfathomable that so many of us work-at-home residents have to wait so long for some relief from such an obvious nightmare. Thank you.
Thank you. Adriana Hochberg.
Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the committee. My name is Adriana Hochberg, and I'm the Acting Director of the Department of Environmental Protection and Climate Change Officer in Montgomery County, here in support of House Bill 934 for the prohibition of use and sale of gas-powered leaf blowers. This bill is consistent with legislative action we are working to introduce in Montgomery County. Phasing out this type of equipment will reduce the noise burden and provide secondary benefits to the climate and to the health of our residents. The impacts of phasing out and eventual prohibition can be minimized now that plug-in electric and battery options are available and cost-effective. Gas-powered leaf blowers are known to exceed the World Health Organization and the National Institute of Occupational Safety and Health standards for daytime noise and occupational safety noise standards. Research shows that gas-powered leaf blowers have specific low and mid-frequency noise qualities or tones that are highly penetrative and result in noise being 2 to 4 times louder than electric plug-in or battery options, both at the unit and up to 400 feet away. The low frequency noise is particularly penetrative of known heavy building materials and easily carries through windows and doors. Beyond being distracting, this noise can have adverse health effects, as has been mentioned, including both auditory, such as hearing loss and tinnitus, as well as systemic with vascular disease and mental health impacts on nearby residents, and particularly to the landscape workers themselves. Transitioning from gas-powered equipment to electric plug-in and battery equipment allows for quieter and healthier communities. These alternative equipment choices have reduced operating costs and a payback to mitigate costs to the business community. I respectfully request that the Economic Matters Committee vote favorably on House Bill 934. Thank you.
Thank you. Chuck Elkins.
Thank you. I was previously the director of the noise control program at the U.S. Environmental Protection Agency. And along with others, I helped inform the District of Columbia City Council about leaf blowers, and this led to their unanimous decision to phase out all gas-powered leaf blowers over a 3-year period, ending this last January 1. So they are now no longer allowed in the district. I'm also an elected official in DC. In my written testimony, I discussed the fact that noise from gas-powered leaf blowers is likely to cause premature hearing loss in most operators of this equipment, even if they are wearing hearing protectors. Most of these workers who use this equipment are not aware of what they're doing to their hearing. Even if they are aware, these workers usually do not have the bargaining power to complain about the danger of the equipment that they are given to use by their bosses. This raises a serious social justice issue for workers in lawn maintenance companies. And this is why phasing out this equipment makes sense even in rural counties in Maryland, as well as in the towns and cities. By voting to phase out the use of these noisy and polluting gas-powered leaf blowers, this committee can protect these workers from further hearing loss. In addition, you'll be providing a much quieter environment for Maryland residents who live anywhere near where these devices are used. As I detailed in my written testimony, all gas-powered leaf blowers are much noisier than their counterparts that are powered by batteries. My testimony provides you the scientific data you need to ban all gas-powered leaf blowers as a class without having to have the use of noise meters in the field. The diagrams I provided at the end of my testimony show this dramatic difference in the characteristics of the noise generated by these blowers compared to battery-powered ones. These diagrams are based on a scientific study I cite in my testimony, a study that a professor at MIT recently decided to replicate to see if he would get the same results, and I'm told his results match closely the results of the original study. And I'll be glad to answer any questions you may have. Thank you.
Thank you. Chris Colby.
Yes, hello, and thank you for the opportunity to testify. I am with Backyard Bounty. We are a small woman-owned landscaping firm in Montgomery County. And about 3 years ago, we replaced all of our gas-powered leaf blowers and equipment, including mowers, with electric and battery-powered pieces. This has been a huge success for all of our stakeholders. Our crews absolutely love it. They love not having to deal with the noise. The equipment's lighter and they don't have to deal with the fumes. Our clients love it. In fact, one of my clients has actually said to me that she doesn't even know when our crew has come until they're gone because the equipment is so unbelievably quiet. And we as a company love it because it helps further our environmental mission as a company. It's kind of hard to be an environmental company and then have all these two-stroke engines moving around. So as much as I would love to continue the competitive advantage of being one of the companies that runs just battery powered, I very much strongly encourage this committee to report favorably on the bill. Thank you so much for your support, and we'd be happy to answer any questions.
Delegate Jackson.
Thanks, Mr. Vice Chair. Mr. Colby, when your business first started out, did you start out with gas powered blowers?
We did indeed, yeah. That was about 10 years ago.
Okay, and then you made the choice to switch to electric or battery powered?
We did, and it's only been, and a couple other people have mentioned this as well, Delegate, it's only been a few years when the equipment has really come up to scale well enough where it is viable and comparable and can absolutely replace the gas powered equipment. The new battery powered equipment is just as strong, just as durable, weighs less, and it's just much better to use. So we've actually, our efficiency has absolutely not decreased, and I would argue that it's probably increased, although I can't empirically prove that.
Did you have the opportunity to plan to switch over all of your equipment?
We did. I mean, it was an investment, right? Several people have mentioned the rebate programs. I know that those are being used in some jurisdictions. They were not available when we made the switch, and it would have been tremendously helpful. Most landscaping companies like ours are small businesses, and this is a significant investment. As much as hearing from the government, I think hearing from customers is what it really matters to us, right? We care what our customers think, and they were the ones who didn't encourage us, but they've certainly been unbelievably supportive in it.
Are you able to clarify what significant investment means?
Yeah, the gas-powered leaf blower with the full batteries is going to run you somewhere around $350 to $400. And that, the 3 to 5 year lifespan on it's probably a pretty good number. It's based just on my experience.
Thank you.
Thank you. Now we'll go to favorable with amendments. Chessa Lutter.
Thank you very much for the opportunity to give this testimony. I'm speaking in favor of HB 934. I'm a 30-year resident of Montgomery County. I have a background in epidemiology and retired from the World Health Organization. I think I'm well versed to speak on the detriments with respect to health of gas-powered leaf blowers. They seriously affect human health. According to the US CDC, they cause hearing loss, tinnitus, cardiovascular effects, immune system suppression, stress hormone release, sleep disturbance, impaired childhood development, impaired cognition, and reduce school and work productivity. They reduce our quality of life. These effects are particularly acute for children, seniors, people with hearing disorders and neurological conditions like autism and sensory deficit orders. The noise produced without any ear protection ranges from 102 to 115 decibels, which is much higher than the US EPA standards as well as OSHA standards that have been established. These are damaging to the environment and they contribute to regional air pollution. They generate chemicals and particulates that violate EPA air pollution standards and emit significant quantities of ozone-forming chemicals. The noise frequencies, the low wave noise frequencies, travel long distances, penetrate walls of homes, and affect homes far distant from the source. In a densely urban neighborhood such as mine, I can hear them from 3 and sometimes 4 blocks away. In my home, while I'm working, I can hear them from 2 blocks away. And in my immediate neighborhood, about 75% of households employ lawn care companies that come on a weekly basis. Given how far out their noise travels, work being done in up to 90 houses can be heard from my house. They always just about violate Montgomery County noise standards, which are virtually unenforced, and they can't be enforced just through a decibel reading. Their use is unpredictable, and I never know when they will cause disturbance. They go from morning to night, Monday through Sunday. They disturbed a Zoom memorial service for my late mother-in-law. And since I continue to work from my home, they can be heard on my weekly Zoom calls with colleagues from as far as Kenya and Geneva. As a resident of Maryland,
I'm going to need you to start to wrap up, please.
Thank you. I urge you to support this bill. And I would also just like to make a comment. One of the delegates mentioned that we were essentially, the bill would expropriate property. My property is being expropriated right now because I have difficulty working, sleeping, recreating, having guests over, because I never know when these machines will disturb the peace and serenity of my own home and yard. Thank you.
Thank you, ma'am. Robert Phillips. Mr. Phillips, are you there, sir?
I'm sorry, I was trying to get unmuted. Thank you.
No, you're
Vice
good.
Chair.
Go ahead, sir.
I'll try to keep it short. Robert Phillips, I am the chairman of the Maryland State Firefighters Association Legislative Committee. The MSFA is in favor of this bill with amendments. We represent the volunteer fire service of the state. Our only concern is the fact that with the sunset on this, and I believe that the amendment will address this from the sponsor. The fire service is not asking to be exempted entirely from the bill. only that we would be exempted from the sunset date until our equipment is out of service, and then it would then be replaced according to the bill. Other than that, we're in favor of everything here. We thank you for your attention to this issue and ask for a favorable report, sir.
Thank you, sir. Now we'll go to the unfavorables. Andrew Bray.
Thank you, Mr. Chairman, and all committee members. My name is Andrew Bray, and I work for the National Association of Landscape Professionals. We share Delegate Foley and other policymakers' intent to reduce carbon emissions from gas-powered leaf blowers as quickly as possible. Still, we must do so in a responsible manner that mitigates the negative financial impact on the landscape industry that relies significantly on the ability to use high-performing leaf blowers. The landscape industry in Maryland has more than 5,000 businesses. 99% of these businesses are small businesses, many of which, as the chairman noted earlier, are minority owned. The issue for us is there continues to be performance, cost, and infrastructure issues. The equipment performance and runtime are common concerns for the landscape industry. And unlike a homeowner that uses this maybe for an hour a week, we're out there using them several hours a day, 5, 6, sometimes 7 days a week. From a cost perspective, I hate to refute some of what has been told today, but I have actual MSRP numbers that says that the most advanced leaf blower on the market, meaning it's the closest to being as capable as its gas counterpart, costs $379. The difference is that $379 does not include the battery, which ranges from $870 to $1,100, and generally need 2 of those in one day because they only have a 4-hour runtime. If you go with a smaller handheld, that's closer to $120 to $240, but those batteries only have 18 to 22-minute runtime, meaning you need 5 to 10 batteries in a day. The infrastructure is another serious concern. We don't have the equipment dealers, we have supply chain issues, right? So we're not even sure if we're going to have that equipment. So I'd like to look at the solutions. I would like to correct the record. In California, they do not ban the use of this equipment, and they've appropriated $30 million last year. They're looking to appropriate $100 million this year and the next year to ease the transition. Okay, those are the facts. I work very closely with California, and California has committed to meet with the industry 4 times this year and have considered extending a timeline for professional uses to continue to use the equipment. The state of Washington is putting in a program that would actually take away sales tax to incentivize. So we support this transition. I commend the landscape companies that spoke about this favorably, that have made the transition. We want to get there as an industry, and I would love to work with the bill sponsor to come up with a solution that works for all of us. Thank you for your time and consideration.
Thank you, sir. Colby Ferguson.
Thank you, Mr. Chair, members of the committee. Colby Ferguson on behalf of Maryland Farm Bureau. We come in opposition to this bill as well, House Bill 934. I think we're kind of the unintended consequence here. We get out into fields, primarily the use on farms is going to be to clean off combines, to get weed seeds, trash out of the thrasher, out of the back of a combine, clean the heads off. I actually, while listening to the testimony here, contacted a few farmers, particularly in Montgomery County, and asked them where they were on this, and they don't support this. They see we've actually had some try to use the battery powered options, even the ones from the more commercial versions from Harbor Freight, and they use the 20 volt 5 amp batteries, and they can't get through cleaning one combine without running out of power. So this is just a challenge when you're in the middle of a field, particularly as you go from field to field during harvest. Having the ability to recharge a battery is almost impossible. So with that, we would ask for an unfavorable report.
Thank you. Stephen Sprague.
Hi, I'm Stephen Sprague with Carroll Tree Service out of Owings Mills, Maryland. Thank you, Mr. Chairman, committee members, for the opportunity to speak. I'm currently the Chief Financial Officer for Carroll Tree Service, but I've been in landscape tree business for 30 years combined, including at all levels, from the lowest level labor worker all the way up through supervision. I had no idea that blowers were so dangerous. It seems like OSHA should be involved if this is such a worker safety issue. I know that there are regulations in place because we follow them and we protect the hearing of our employees and enforce those regulations. If people were dying of diseases. I have not seen that. But it just really shocked me. Some of the other comments I heard shocked me. I live in a house. I work from home. I don't remember ever thinking, oh my God, I wish that blower would stop. But also we service a wide variety of customers in all different types of settings, whether they be townhomes or large estates, schools, institutions, colleges, municipalities, government institutions. I handle all of the customer complaints that come into this company. We have 57 people, been in business for a long time. Demands to stop using blowers because of just the noise that people just can't take. I've never had one of those complaints. That's not to say that certain homeowners associations do not have things in place that say, you can't run a blower before 8 or after 3. That does happen. All that being said, this is going to increase our costs. It's going to be burdensome to get rid of all the gas power, get the electric in place. We have the battery power problem. We have the battery disposal problem. We have the recharge problem. We have the chargers in the field problem. It's going to negatively impact our ability to compete with lower level tree companies. This is a completely bifurcated industry, and much of it operates outside of regulations. Absolutely. It's going to be very burdensome on our business, and we would ask for an unfavorable. Thank you.
Delegate Watson.
Thank you, Mr. Sprague. Can you remind me where your business is again?
Owings Mills, Maryland.
Thank you. And how many employees do you have?
57.
Okay, so can you just explain to us what kind of safety precautions your workers take when they're using these leaf blowers, or that you require your workers to take?
Yeah, they all wear ear protection, and in our case, it's ear muffs that are rated to protect them from that noise level. We also use chainsaws and chippers, which are much louder, actually. And so they're using hearing protection that protects them from the decibels of all that equipment.
Do they use any kind of respiratory protection?
Not when they're running a leaf blower outside. Now, if they're running a two-cycle piece of equipment indoors for an extended period of time for some reason, then they would be using respiratory stuff, but that's not an issue. And it's also not
required.
OSHA would require that if it was a real health problem.
Okay, thank you so much.
Yep.
Thank you. John Akehurst.
Good afternoon. I'm here in opposition to this bill. I represent, standing talking on behalf of the Maryland Nursery Landscape Association and Greenhouse Association, the Maryland Green Industry Council, and on again, like Mr. Sprague, a boots on the ground, dirt under the fingernails guy with my own landscape company that has been servicing the state of Maryland for over 146 years this year. A lot of the things have been said, but I just wanted to point out a couple additional things that haven't been spoken. Just the cost alone of switching to electric equipment over the gas. The technology is not there yet. I have yet to find an electric blower that can run all day, especially when you're doing leaf removal. We could be running our blowers 60 to 70 hours a week. Electric, you're going to be going through batteries. Somebody mentioned earlier in this discussion about disposal of those batteries. And I have the question, are we trying to fix a problem while creating a bigger problem? I think further research needs to be done for this. I also think the rollout time of this is too quick. Someone was asking what the cost was. I quickly calculated my business. When this thing kicks over, I'm basically going to be throwing away $150,000 worth of equipment that I can't sell to someone else. What am I going to do with it? Also, emergencies. We had a hurricane back in, I believe it was 2009, Hurricane Ida. My office was without power for 7 days. And you're telling me that I won't be able to operate and help my customers when they needed help the most of cleaning up their yards because I can't charge my equipment. So I am opposed to this on so many levels. I see that I'm out of time, but I'd be happy to invite those that are in opposition to put some boots on and get dirt under their fingernails with me so that they can see the real world. Thank you.
Okay, thank you, everybody. That concludes the hearing for today. Subcommittee chair, immediately following this, there is an additional link, and we will be meeting with the chair. Thank you all so much.